Let's talk about a living trust-centered estate plan. Your revocable living trust is the center of a good estate plan. Your living trust holds and controls your real property, bank accounts, investments, and many other assets. By the way, if you'd like to learn a bit more about living trusts, the Learning Center portion of my website has several informative videos about new and exciting strategies for protecting you and your loved ones with the revocable living trust. Anyway, while your revocable living trust occupies a central position in your estate plan, there are other important documents you need to learn about. For example, a good living trust-centered estate plan should also include a document called a PourOver Will. This type of will is used to name guardians for your minor children, or if you've left out an important asset from your living trust after your death, the PourOver Will probates that specific asset through the court system, and the beneficiary of that will is your living trust. In other words, your PourOver Will puts left out assets back into your trust where they belong. An important financial document in a living trust-centered estate plan is your durable power of attorney for property. I know the word attorney is in the title of that document, but it has nothing to do with your estate planning attorney or any attorney at all. The attorney I'm talking about in this document is your attorney in fact. Your attorney in fact is the person or persons you've selected that can sign your name to documents in case you can't. For example, if you're incapacitated, your attorney in fact can sign your name to tax documents, government forms, and other documents that may require your signature. And since your attorney in fact is your fiduciary, he or she is liable if they abuse the privilege you've given them. It's vital that your durable power of attorney be coordinated with your revocable living trust so that nothing financially important is overlooked. And finally, there is your advanced healthcare directive. This is the document where your medical wishes are spelled out if you are unable to communicate. In this document, you also spell out to medical professionals the names of the people that can make medical decisions for you. The healthcare directive also states whether you want to be an organ donor or not, and whether you want to be buried or cremated, and other important wishes. The healthcare directive can be very specific in any number of healthcare areas. All of the parts of your living trust-centered estate plan need to be coordinated. Each document concerns a specific area relating to the control of your assets, or your personal health, or your financial needs and wishes. One document can't say one thing, while another states just the opposite. Each document has to spell out your wishes in a clear manner and spell out which person or persons can answer for you if you're unavailable, incapacitated, or have passed away. Look, I'd really love to sit down with you and discuss setting up or revising your living trust-centered estate plan. There's a lot to talk about. I hope you enjoyed my little video. Please feel free to share it with friends and family. I'm estate planning attorney, Hollis Logue.